So what, is it just a stick? Like,
Okay.
You have
the more
that
she filled with cement, and it's a stick, and then she just individually wrapped,
the Zoom.
some like little pieces
Good
of
Lord.
it.
I would be.
It's Jay Create. There you go.
It's so festive. Crying laughing. It's so festive.
Technology.
Oh, it just makes my disc wet. It does.
It's nice when it works.
It does. It does. Instant anxiety.
Okay, can everyone hear okay? So I thought that was decoration.
Now, can we leave that here?
Yeah, that'll work. I love it.
Rich, do you-
Can you?
Somebody's
hear
asking
that?
for the Zoom.
Oh, the Zoom link?
Yeah.
I was gonna say, you sent it out this morning to everybody.
I love it.
She
Yeah,
must not,
it's
she
all
must
I
not be on
love.
the text messages.
Yeah. I can share that with her then. I mean,
Well, I can
That's
hear
what,
people.
that's what I was gonna share with you.
Okay, I have that. so I
Okay.
didn't think of that.
Yeah, that's okay, yep.
Hey, Heather Mahillis, can you say something just for us to check if we can hear you?
All my nieces have this cancer. Okay, perfect. Selena said yes.
Lane said yes.
Okay, all right. So then
Okay.
you stand up here. That look normal?
It looks like, yeah, it looks like everybody. This is like, I didn't realize we had a 360 camera.
Hi, guys. I can hear you.
Awesome, thank
Thanks, Heather.
you.
And we can hear you.
Should be good to go.
Thanks for your help. Is it
Yeah.
recording or do we need to record
Yep,
it?
it's recording.
Okay, cool.
Yep, you're all good.
Awesome. Thanks, guys. Caitlin. Okay, everybody, I'm gonna stand up here next to Mike Gruber. So Mike is our attorney. at-
Make sure we give the,
Do that.
I'll make sure that I have the camera off
Up to mute you folks.
for them to see, you know, what them to see.
You,
No.
cover over them. And
I don't know. I don't.
do that.
Oh, wow.
Okay, so Mike Gruber, I'm not gonna say how old you are because I don't know, but he's been the board attorney since I came around in
About
2000.
1980.
Yeah, so long time. He is also our attorney here at Keller Williams Legacy Group. And we get questions constantly about how do I fill out, like, how do my clients fill out LLC documents as far as the listing paperwork? You know, if they have an LLC or a trust or a will or whatever that is. So we figure this class is going to be very, very important. Ask my questions. We're going to pop an outline. I don't know if we need the outline up there or not, but
That's up to you, whatever.
I will attempt to put the outline up. Did everybody in the class get a copy of the outline yet?
It's out there on that. paper.
Okay, let me grab those. Mike, go ahead and take it away. Thanks for doing this
All
for us.
For now, I may sit here, I may get up and wander because I don't have a period of time. Thank you for having me this morning. As Rich said, I've been the board counsel since about 1980 and represent real estate brokers since I think it started 1979 with Bobinger. It's the name that some of you might remember. Anyhow, we've been seeing a lot of different dips and peaks in the real estate market, and as those happen, transactions change. We have gone from a lot of different things, bad times with lots of land contracts, good times with easy financing. But one of the things we've been seeing recently is more and more use of entities in the real estate market. And there's a good reason for that from an ownership standpoint. When you use an entity, the biggest reason you do it is to shield the owners of the entity from liability. If you have liability, you want it in the entity, you don't want your personal home, et cetera, at risk. So if you use the entity bears most of the risk and creates a liability shield for you personally. One caveat to that is whatever you personally do, you can be at risk for. So there's a lot of single member LLCs. Whereas someone wants to own a property, instead of owning it in a personal name, they use a single member LLC, one owner of the LLC. And that's important because as soon as you have two owners with an LLC, It's a separate entity for tax purposes. It has to file its own tax return, et cetera. A single member LLC for tax purposes is called a disregarded entity. You just bring everything on your own personal tax return as if you didn't have an entity. So you can see you've got benefits on a tax side. It's like owning it yourself. But on the other side, you've got liability shield for issues that could come up, liability problems, legal problems in the entity. The reason I brought up things you do yourself is with a single member LLC, who's going to take all the actions? The member, because there's only one person. But if you hire people in the entity, you get a liability shield for what they do, and you get a liability shield for corporate acts. But let's say you own a rental property and it's in a single member LLC, and there's a problem with the front steps, and you personally go and repair the front steps. You don't do it right, someone trips and falls. You can still be responsible for that because you did the work. If you had hired that work out to an independent contractor, some company, then you'd have a liability shield for it because the company that hired the independent contractor, they did the work. So just keep in mind, if you do something yourself and you don't do it properly, you can have liability for that. But things that other owners do, things that employers do, or employees do, things that independent contractors do, you do have liability shields for all those things. So limited liability companies are relatively new. They're probably the Ohio statute that authorized them in Ohio is approximately 20 years old. In the legal terms, that's relatively recently because you have to get a body of case law built up to see how courts are going to interpret these. So in the beginning, people were afraid of them. Are you going to get the same liability protection you get from a corporation? And the answer is yes, you do. So the original concerns with LLCs are gone, and that's why they're becoming increasingly popular. One of the reasons we like an LLC instead of, let's take it easy, sole proprietorship, we just talked about that. Partnership, there can be some liability protection. The problem with the partnership is, yes, someone going after partnership would have to go over partnership assets first, but once those are exhausted, the partners are personally liable. So partnerships are not the best vehicle because you don't get a true liability shield. Corporations, you do get the liability shield, but there's a lot more formalities with a corporation that you have to follow. And if you don't follow the corporate formalities, then if you get into a lawsuit, the plaintiff's attorney will say, this is a sham. They didn't follow the corporate formalities. And that's called piercing the corporate veil. So there are many, many cases where plaintiffs' attorneys were able to pierce the corporate veil, get at the personal assets of the stockholder because they didn't follow the right formalities of a corporation. We get around that to a degree with a limited liability company because you don't have the same statutorily required corporate formalities you do for a corporation. With a corporation, you file an articles of incorporation. The liability company, articles of organization, very similar to get started. After that, with a corporation, you have bylaws or code of regulations. Those two terms are used interchangeably for the set of documents that govern how the corporation is to be operated. But that's against the backdrop of the corporate statutes that say what you have to do. With the limited liability company, you have what's called articles of organization and then an operating agreement. And the operating agreement is basically a private contract among all the owners of the limited liability company that says, how are we going to run this thing? There's very little in the way of statutory regulation. So you can be very creative in what you do. With a corporation, you have to have an annual meeting. The limited liability company, you don't. And that can be a big deal as to whether you're following corporate formalities. So a good, well-drafted operating agreement for a limited liability company, especially a single member or one that only has a couple members that are owning real estate, is to say, yeah, you can have a annual meeting, but it's not required. So as soon as you're not requiring those things, you're getting away from reasons that your entity can be attacked. With an S corporation, a lot of people have heard of that. You use that to be able to bring those things on profits, losses, et cetera, on your personal tax returns. But there's a lot of rules that the IRS has on S corporations. One of the biggest ones is you can't have more than one class of stock. And that's important. As a limited liability company, what you own is called units of ownership, and you can have different classes. So we have done a lot over the years where you have someone that owns a business, you get into succession planning, estate planning, all those kind of things, and you want to start giving ownership to people, but you don't necessarily want to give control away. So you can do that with voting and non-voting units. So you can get creative that way with LLCs. And from a planning standpoint, they're much better. And you can't do that with an S corp. So these are all the different reasons why the limited liability companies have become more popular over the years, especially with owning real estate.
I have a question.
Sure.
Okay, so you can like give shares to other people in an S corp, is that correct?
Well, yes, you can, but there's limits on the number of shareholders in an S corp.
Okay,
And there's limits on the fact that you can only have one class of stock. So you can have multiple shareholders,
right.
but you can only have one class of stock. And distributions have to be equal based on
Okay.
your percentage of ownership. Within a limited liability company, you can have unequal distributions. So it's just a lot more creativity and planning and things you can accomplish with an LLC than with an S corp.
So I feel like I've heard people say, well, they have an LLC, but then their accountant puts it through as an S corp on their tax purposes.
Okay, that's called
Like a pass.
people call it a check the box election.
Okay.
You create an LLC. And then when you file with the IRS, there's a form where you check the box. Do you want to be taxed as a sole proprietorship, an S corp, a C corp, or a partnership? So depending on what box you check on that form with the LLC is how you are going to be taxed. So yes, you can have an LLC that is taxed like an S corp if you check that box. But then you get into the S corp limitations. So if those limitations on an S corp work for you, fine, check it that way. We have found that there's a lot of, maybe not a lot, but there are accountants out there that are not real familiar with limited liability companies because they don't use them, they don't like them, they're not familiar with them, they're familiar with corporations, and they push, oh, we'll just do an S corp. One of the reasons that we have to work with them is from a planning standpoint, we can do more, and you still get that liability shield. So some of the concerns that accountants had about whether that liability shield is effective, like I said, we don't have anymore as attorneys because over the years, we've seen how the courts have interpreted this and they've upheld that liability shield.
So as an agent, since that's, I mean, there's kind of twofold. So you're here for kind of the agent part of it, but also the client part of it.
Right.
So I guess my question would be, since we're on the topic of LLCs, unless it's later in your outline, what do you recommend that an agent as a licensee create an LLC for themselves and be paid in that manner as opposed to a person?
Yes, we do recommend that to the extent you can get the liability shield with professionals that are licensed by the state. You have to look at the professional licensing as to what you're responsible, what you're not responsible for. And under license law, you have obligations and responsibilities, and you can't avoid those through the LLC. So to the extent you do something that's a violation of license law and a client wants to pursue you for that, the LLC won't protect you because that's a license law issue and it's something you either violated or didn't. But from a standpoint of operating your business, if you'd be out and there's an automobile accident or any myriad of different issues that come up, liability issues with a company, you can still get those kind of protections. So, and the other thing with individuals that aren't real sophisticated in business entities, since an LLC has fewer formality requirements, we think it's better for a lot of small business people, independent contractors, et cetera, because don't have to worry about all those corporate formalities.
Okay. So then from a standpoint, when we go out and talk to our clients and you're talking about an LLC, I assume we should ask for something so that we know that they really are an LLC and who the members.
Well,
You're gonna
we'll get into
We'll get
that.
No, she's
So,
gone.
all right.
Go ahead. Sorry.
Can I
Bob.
ask a
Yeah,
question?
so that's fine.
I just
Yeah,
have one more question. So when you said that about the S corp, so if you have an LLC set up, and then when you go to do your taxes, is it better to just leave it as an LLC to do taxes, or is there any benefit that there would be to have the S corp to check? that
no,
box?
not really, because the reason you do an S corp is to not be taxed at the business level, bring it all onto your personal tax return.
I got you. Okay.
And that's what you accomplish with a single member LLC.
Okay.
Remember, one of the times where you might use the S corp is, say you've got 3 or 4 investors that all want to be involved. As soon as there's 3 or 4 owners, now it's not disregarded as an LLC. So there you may want to check the box as an S corp, because even though there's 4 owners, you still get to bring that on to your personal tax return for your share of the ownership. And that's why with married couples, we say pick one, husband, wife, it doesn't matter, because you're probably filing a joint tax return. But if you only have one, then you're a single member. But as soon as husband and wife are both on there as owners, now you're a multi-member LLC. You've got to file a separate tax return for it, as opposed to bringing it onto your personal tax return. So we have this document, an operating agreement. And we try to make sure that every LLC we work with has an operating agreement, because legally, as soon as you file your articles of organization, which is like a very sparse 2-page document with the Secretary of State's office, you're considered a legal LLC in the state of Ohio. But until you create your operating agreement, you're at risk for being considered to be a sham. Can you operate under what's in the statute as an LLC? Yes. But the operating agreement, which is like the bylaws of a corporation, without that, it's easy to attack the LLC. So while technically the statute does not 100% require an operating agreement, we strongly recommend that for every LLC that we deal with, because it really helps solidify that liability protection. The operating agreement says how you operate, and you have choices to make. For example, you can be what we call member managed, which means every member has a equal share in the membership, and you have meetings like a partnership, and you vote, and majority rules. You can be have a manager where you, as the members of the limited liability company, they pick a manager, and the manager runs the day-to-day operations. And the document will say, here is what the manager handles, which like I said, is most of the day-to-day functions. And here are things that take a member vote. If we're going to dissolve, if we're going to purchase a major asset, those kind of things. So you can limit the authority of the manager in the document, but generally the manager would run the day-to-day operations. Or you can have officers just like a corporation. You can decide you want to have a president, a vice president, secretary, treasurer, the whole thing. And the operating agreement will say that. So really have to look at the operating agreement for every LLC to know how it's managed and who has the authority.
And that's why the title companies ask for this document when they see an LLC. It's interesting, I mean, I've been doing this for almost 20 years, and there are some title companies that ask for this document and others that don't ask for it at all.
It's amazing the different level of competency.
I mean,
I do.
You see some pretty surprising things out there.
So for the operating agreement, that's just like something that's with the business and if people ask, you give it to them?
If you choose to give it to them, you don't have to. One of the things sometimes you use is an action by written consent. And so those are available to corporations also. And it's a document. And the operating agreement will say to use an action by written consent. What that is, you write down what it is. We're gonna buy this building. And you approve to buy this building at such and such a price. And then in it, it should say who then has the authority to sign the purchase agreement, the deeds, the closing statements, all the rest. And everyone signs it. Or sometimes a operating agreement will say you only need 2/3 or 75% or whatever, a certain percentage of the members. But the default is 100%. So if it doesn't specifically say a lesser percent for action by written consent, and that's similar for a corporation, you need 100% of the members. And if you have 100%, say a title company shouldn't question an action by written consent, giving that authority. But let's say you've got 10 members of an LLC and 7 of them have signed. Well, that's good if you only need 2/3. So in that situation, the title company may still ask for the operating agreement so they can verify that you only needed 2/3 of the members to authorize what's being done.
but typically as an attorney, you would write the articles of incorporation, or you would do the articles of incorporation with the Secretary of State's office, and you would also create an operating agreement
Correct.
for the LLC, right? That's part of it.
Correct. And it's not cookie cutter. People tell us, oh, just use your standard one. Well, yeah, about 50% of the document could be what we call boilerplate and a lot of standard stuff. But there's a lot of decisions the owners of an LLC need to make. Like, do you want to be member managed? Do you want that action by written consent to have 100% or lesser? You know, all those different kinds of things are choices that the members can make with an LLC and we put in. So when you get into a real estate situation and you are, say, a listing agent, who is it that can sign the listing agreement?
Most of them don't even know.
I
They have to go
understand.
read it because they don't know. They tell you one thing and they're like, oh, I didn't know that.
Well, and a lot of times, well, I Googled it and they said you only have to file this and we filed that. Well, yeah, but then they never do an operating agreement. So a lot of times when we get involved, after we talk to the client, they understand that they need that operating agreement and we get it created for them right away so that then they, number one, get the protection they should have, and we can deal more easily with the title companies of the world in making sure that their transaction gets done promptly and efficiently.
So if I'm a listing agent and I go out and I hear or see that they're a member of an LLC and I don't know and they don't know, what's my best course of action? Because typically we go out and they say, well, I'm an LLC, or we might see it on the tax records that says I'm an LLC. And agents automatically assume that it's a one-member LLC. We don't know. They just
Right.
assume that. They take the listing.
That's a dangerous assumption.
Right, so basically what you're saying is unless we are given the operating agreement and can see that this person has the legal capacity to enter into a listing agreement, we should not be taking a listing that has an LLC named unless they can provide that. Is that?
Yeah, I mean, it's sort of like the old thing about listing with married couple and only having one of them sign. I mean, you've got a problem here, and the quicker you get that problem solved, and you don't know how big the problem is until you're able to get that second signature. And the same thing with that operator. We have found out that maybe there were 2 people and they had a falling out. One has just been running with it and operating it, but technically that other person is still involved. the quicker you find those things out and deal with them, the far better off you are.
Because we get that question all the time. People call me constantly asking that question. Well, this is an LLC. How do I get them to sign? And two, how do I know who can sign? Well, we need a copy of the operating agreement.
Yeah,
The title company's gonna want
right.
I always get it up front, just to
And you
save
should.
time. That's the way you explain it.
Yeah.
So, hey, look, we can save quite a bit
Yep.
of time by getting this up front. period.
It's just dealing with the dentist, and it's an LLC, and he said, oh, do you have an operating? agreement?" Well, yeah, there was that pack of papers I had, but I'm not sure where it is. Well, you think you can find it? Well, I'm not sure. Well, who did it for you? Well, that was like 10 years ago, and I don't think he's around anymore. I mean, so even though he thought he had an operating agreement, we had to create a new one. Because he wasn't 100% sure, and if he had one, he didn't know where it was and didn't know what it said, so.
So the answer is, if they don't know where it is, if the client can't find it, they need to get hold of an attorney and get one written before we list the property.
Absolutely.
Not an attorney, Mike.
Well, of course, Mike. That goes without saying. Please, my turn.
So
So you wondered why I asked her to come.
Right?
That's right.
She's a plant.
I had to step out to take a phone call, but are you saying every LLC should have an operating agreement?
Yes. Technically not required by statute, but it is your bylaws. It's how you govern the LLC. And without that, it's too easy if you get into a legal situation for a plaintiff's attorney to try and attack it and say, this is a sham. They have never followed any formalities at all. They've handled it as if it was their own just personal asset. And so, they'll say, tell a court you should disregard that LLC. Yeah. All right. I put in here, there was a question about how things get signed. And on page 2 of my outline, I gave some examples. An LLC is going to be signed by who the operating agreement says is authorized. If it's member managed, then would be the name of the LLC by the person, and we use its authorized member. Okay,
Is that what ITS is? What's ITS?
it's
Authorized member.
authorized member.
So that's what you would fill in there. It's
Yeah.
authorized member.
Just like on the next one for corporation, let's say the president's authorized, you'd say by John Doe, it's president. And then you'd see in the action by written consent that the president's authorized. So that ties in with here, it's by so-and-so, it's president. So that's it, is saying, what is your corporate authority?
Okay.
Now, sometime we have an extra line in there too, just asking people to print their signature, which is just helpful for other people that are looking at it. But this is what's legally required. And if you compare that to a trust, you have to remember that trusts don't hold real estate in Ohio. The trustees hold title to the real estate. So deeds are always to and from the trustees of the trust. That got to be such a problem that a couple of years ago, as part of what we call a saving statute or a statute to fix problems, we can now deal with deeds to, the trust as opposed to the trustee. But you don't want to get in a situation where you got to use a saving statute to try and fix a problem. Far better not to have the problem to start with. So your contracts should also be that way. Contracts should always be with the trustee of the trust. So if someone has a trust, even if it's just a revocable trust for estate planning purposes, and that's the way they have their house. If it's Mary Smith, trustee of the Mary Smith Trust, dated, and that's usually in the formal name of a trust. It's got the date of the trust. But then Mary Smith, trustee, is who signs the listing agreement, who signs the purchase agreement and all the rest. So when you're dealing with a trustee, make sure it's the current trustee and make sure that they sign that way. Now, with trusts, it's easier because the law provides for a memorandum of trust. That's a document that gets filed in a recorder's office because you don't have to, if you have a trust, have all your personal information and all your decisions of record. But a memorandum of trust says, here's the trust, here's who the trustee is. That person dies or becomes incapacitated, here's who the successor trustee is. And here's the powers that the trustee has, because in a trust, you can have very broad powers, like in a general power of attorney, or you could have very limited powers, depending on how you set that up. So some trusts say the trustee has unfettered power to buy and sell real estate. Other ones say no, that there are limits on maybe what they can spend, or they are maybe a trust advisor they have to consult with, or they have to get consent of beneficiaries to sell real estate. So those powers of the trustee are in the memorandum of trust. And that's all that has to be there. So the information you need from a real estate transactional standpoint is in the memorandum of trust. And if you're dealing with a trust and they have not created and filed their memorandum of trust, they should do so right away, because the title company is going to want that. Otherwise, they're going to demand to see a full copy of the trust. And most people don't necessarily want to give out full copies of their trust. So memorandum of trust is so easy to prepare and file. And there again, at the outset, whether you're working with a buyer trustee or seller trustee, find out if they have that memorandum of trust filed. If they have one, get it, make sure it's a recorded copy, and that'll tell you exactly who should be signing the documents.
So Mike, while we're on that, if I can interrupt you for a second. So I don't know if anybody's ran into this situation, but I feel like I've had this question before. So let's say we have two sisters. They own a house in the name of the trust, or they are each a trustee. So they own it. One of them has passed away. The other sister wants to list the property for sale. So based on what you just said, there should be something else filed telling that there should be a successor. If there's not a successor, where am I at? Let's say there's no successor. I don't know why somebody would do a trust like that, but maybe that person passed away.
Well, here's
first.
what happens. A lot of times it's mom and dad. Mom and dad have passed away, and they appointed their child or one of their children successor trustee. And that person has passed away or is incapacitated, or they live in California and they refuse to act.
Okay.
Okay, there should be another successor trustee. If not, now no one has authority in the trust, which means you have to go to the probate court to file an action. You have the probate court appoint a trustee.
And I feel like that's happened in transactions before,
it's happened.
where they've
Yeah.
all passed away and there
Yep.
is no person to sign. So in that case, I've seen agents take a listing, unfortunately, not paying attention, then we can't sell the house.
That's exactly right.
So,
We have to go through a probate court action before you can sell and close on that house, to get the probate court to appoint somebody that has the authority then to deal with the property.
perfect.
Yeah. Okay. Then we have a partnership, and you don't see many partnerships anymore. I mean, really, the LLCs have almost made partnerships go extinct from the situation, because no one wants that liability still hanging out there that you can so easily avoid. But if you do have a partnership, remember there's two kinds: a general partnership and a limited partnership. With a general partnership, all the partners by default have to sign. You can file a certificate of partnership with the recorder's office that again says who the partners are. And if in the partnership, they have delegated authority to one or more partners, that'll be in the certificate of partnership. So again, either you're going to have to see the full partnership agreement or a certificate of partnership to know who can sign. Default, if you don't have any of that, is 100% of the partners need to sign. With a limited partnership, you have limited partners that are like stockholders, and a general partner who runs the business. The general partner always signs transactional documents for a limited partnership. But understand that the general partner doesn't have to be a person, it could be another entity. So I've seen limited partnerships where there's a corporation or an LLC that's the general partner. So then you have to say, you know, ABC Limited Partnership by Real Estate LLC, its general partner by, and then the right person signing for the LLC. So those signatures can get a little complicated. But again, we're not seeing that many limited partnerships anymore either. But just keep in mind that a limited partner is the one that does it, and the limited partner may be another entity. When you want to, for a corporation or an LLC, know exactly what's going to happen in a specific transaction, from the very beginning, let the people know to close, you are going to need that action by written consent or a corporate resolution. They should be working on that, getting it up front, because signing the purchase agreement should be authorized, as well as all the closing documents. And again, we've seen too many situations where you've got a deadline, there's a tight closing window, and all of a sudden you got a title company that's asking for these documents. And it's a fire drill to try and find people, get them prepared, get them signed. So much better to know what you're going to need, and at the very beginning, start the process to make sure you've got the right documents signed by the right people.
Mike, before we move on from LLCs, I know a lot of agents have asked the question, so a property is listed in the name of an LLC, it's an investor, let's say, for example. They are married. Do they need to get the significant other's signature on the LLC if it's a sole member LLC?
No, because there's no dower interest in that personal property. That unit of ownership in the LLC is personal property. The real estate is owned by the entity, even though for tax purposes, it's disregarded. For real estate transactional purposes, it's not.
And does an LLC, are they recognized by the state as being exempt from filling out a residential property disclosure form?
They are I didn't look at that. That's a good question.
Sorry to put you on the spot.
No, that's okay. It's been a while since I looked at that.
Because I don't think they're
It's
listed on that
it's not an
form.
exemption on the state.
I'm just gonna say, I'm trying to think through the exemptions, and being an LLC is not one of them, so I think they have to fill it out.
We've always recommended, but I know that there are agents or brokerages out there that will argue.
Yeah, and like you said,
Well, sometimes an LLC, if they're rehabbing, knows more about the house than a homeowner would though.
Sure.
Absolutely,
I mean,
yeah.
But I see a lot of them say
Right.
that they fill it out,
never lived
but
in a
but they
house.
say they never lived there and
They still have to fill
don't
it
have
out,
any
though.
knowledge of that, and then they sign it, so.
Yeah, but technically that never lived there. It's only someone that took it through an estate
Mhm.
and hasn't lived there.
Right.
So that's
Yeah, I
technically
know.
the only exemption for
Right.
that. But I like people when they say they don't live there, because to me, that puts the buyer more on notice. That, all right, we're getting this from this person, they've never lived there, so I better not waive that home inspection. And I
Right.
better make sure I go through and I know what the inspector's finding, and if there's any issues, look into it, because the person that's filling out that form says, telling you I never lived there, so their knowledge would be limited.
So what if you have an investor that purchases a property out of their LLC, but they have everything else, I guess, in a trust for
Mhm.
themselves? Does the house go under the LLC name on the deed, or does it go in the trust?
Well, are you saying buying or selling?
They're buying,
That's their choice.
okay.
They can choose to have it be a trust asset and convey it right to the trust, or they can choose to have it in the LLC. And there's some reasons why it's good to have it in the LLC, and then maybe have the trust own the units of ownership in the LLC, because now you've got a liability shield again, to shield the other trust assets. And a lot of that depends on the kind of property. Some properties, say it's a retail strip center where you got a lot of people coming in and out, and you got trip and fall cases and, falling on the snow and ice and all that kind of stuff. That kind of property is a lot more risky. So you may want to do it for that purpose, to shield the other trust assets.
Okay.
The always getting the deed is the best to see, to review exactly how property's held. A lot of people do rely on the auditor's records and looking it up on the auditor's page, and that's pretty accurate. I mean, you don't find problems that often, but you can't guarantee that 100%. Getting a copy of the deed is always the best practice to have. That way you also know, from a legal description standpoint, exactly what you've got. Had too many situations over the years where someone thinks they're selling 1 or 2 lots, but the deed they're using only has 1 lot and all those kind of things. So you want to see the deed anyhow. It's just best practice to get a copy of the deed, and that'll tell you exactly. Now, sometimes people change names, and you can freely and easily change names on LLCs and corporations. So just because it says one thing, they may be operating in a different name. So that gets a little tricky in dealing with contract documents. Excuse me. We normally say, I'll call it NewCo, new company or whatever, formerly known as or having taken title as. You ever seen HTTA in a deed or a contract that's having taken title as, and the name's changed? So it just alerts everybody that the name and record titles can be different than what this document is saying, but they've gone through the right legal steps to make that a legal name change. So everything's okay. Sometimes if you're dealing with commercial or investment properties, banks require single asset entities. Generally called a single asset bankruptcy remote entity. And that's because the bank who's loaning money on that doesn't want problems from other related properties. They tell the borrower, we'll loan you the money to buy this, but you have to put it in either a LLC or a corporation that is single asset. This is the only asset that's going to be owned by this company. So you have to have, if you're going to do multiple ones, you might have multiple LLCs or corporations, but a lot of banks want that because they don't want a problem over here to take down this property, especially if they're only loaning on this property. So you'll see those too.
Mike, it's a little bit off topic, but you brought up the name thing, and I feel like I get this question an awful lot too. So I'm a single person. I bought a house, and now I've recently gotten married. I've gone through my legal name change, and I am now known as somebody different than I was on the deed. How am I signing the listing agreements, purchase agreement, and closing documents? What am I doing? Can I sign in the new name?
Yes, that is your current correct name. So while you can do the old name, I think it's better to use the new name and use HTTA, having taken title as, or FKA, formerly known as. You'll see both of those initials, and either one works. I think having taken title as is more accurate. And you also sign that. So anyone looking at the contract will be able, and title companies know this, they run both names. Okay. Because they'll run your old name to see where you took title. They should then verify the legal name change, and now they also run the new name, because you could have tax problems, judgment problems, anything in either one of those names now. So it's important for the title company to know both. And since your new name is your new legal name and legal signature, that's the way you should sign, even though you're showing on the document that you took title in a different name. Okay, thank you. I think we've covered a lot of this. That's in the outline, we took a little out of order, but I think we talked about it. One of the things I did also want to bring up is, I don't know how much you deal with new construction. But if you're dealing with a builder and they have built a spec home, they have an existing house that they're selling like any other house. If you're selling a lot, and also there's going to be a new home built on that lot. So you're combining like a construction contract and a real estate purchase. Or I've seen situations where a house might be framed when it's sold, and you have to sign an agreement with the builder to finish the house. There is a statute in Ohio dealing with residential construction. And if you have a residential construction that exceeds $25,000, so if that house is framed and it's going to take 80 grand to finish it, that exceeds $25,000, it deals with construction, you have to comply with the statute. And there's a whole handful of specific provisions that have to be in that contract, or you expose the contractor to significant liability. So bear in mind that, you know, that's something that either the contractor's attorney should be looking at, because new construction, like I said, if it's a completed house, you're fine. If it's a spec home, it's done, you're just selling the house. But if there's elements of construction work that's going to happen in the future, and you're dealing with it in this contract, and it exceeds $25,000, there's a specific statute that comes into play that has to be followed.
So is there something as a listing agency that we need to be doing? So there are a lot of builders that use their own purchase agreements.
Right.
And we know that, and that's, we don't.
And
really
then
have
that's a real help to you from a liability standpoint, that that's their baby, and if the contract's wrong, it's not your fault.
So let's say though, we find a vacant lot and our client purchases that vacant lot, it's now in their name, but we also brought this particular builder to their door as well, and this builder is now going to buy or build their dream home on this lot. So if they don't have their own purchase agreement, is that something that you're saying as a?
Well, keep in mind what we're talking about. If your contract was just to buy the lot, then they enter into a separate second contract for constructing the home, you're okay.
Okay.
Because your contract was just for the real estate. What I have seen is a contract for that lot, and then there's like an addendum added to it that, you know, John Doe Builder is going to build their Shenandoah model, and, you know, 2 more addendums to it with, they're making different choices and that kind of stuff. They're trying to blend the construction contract in with the real estate contract. That's where the problem comes up.
Okay.
Yeah. So it's when you're combining it into one contract that you gotta be careful. If it's a separate contract just for the sale of the real estate, the lot, you're good. It's just all your traditional concerns.
So the builders, and only because you're on this topic, I want to try and get a lot of questions answered that I get on a regular basis, because it's important for you to be able to tell us what the right answer is. And one of the things that we see a lot of, let's say it is a Ryan home, and I'm going to use them as an example because they do use their own purchase agreement, and we've taken, you know, people to them. They use their own purchase agreement, which is great. So you're saying that's a great help for us. It's a great
Yes.
liability off of us as a real estate agent.
Because companies like Ryan have all the right things incorporated into their contracts.
Okay.
You know, they know it, they got it. Where we see typical is the smaller local custom builders who are working with a realtor and they're throwing things in together.
Okay. So staying on that note, we see a lot of times the builder, for whatever reason, or the representative refuses or chooses not to sign the agency disclosure form, which we think is a problem as a brokerage. We say, you know, it's got to be signed by both parties. They're not exempt from signing that form as a builder, correct?
Right.
Okay. So the only thing we can do is note on there that they won't sign it.
Correct.
That's all we can do. Is there a reason that you feel that builders don't sign that or don't want to sign it?
I think it's a lack of knowledge. A lot of times it's local managers that just don't understand. Usually when we can get on and talk to them, talk to their senior people, talk to their real estate council, et cetera, it gets taken care of. But a lot of times the local managers, especially if they're new, they just don't understand. They're afraid to sign documents that they don't think they've been authorized to sign. I think it's an educational thing.
Okay. So as long as we document on there that they refuse to sign it, that's about all we can do.
That's
And
all we
I
do.
think that almost leads me into the same thing with the bank-owned properties that we'll probably start to see popping up again. The asset manager never wants to sign our agency disclosure forms for whatever reason. And that, what's the best course of action there?
Well, and again, one thing I'll bring up in both the situations, but especially with the builders, be careful. Because the builder, Ryan Holmes, whatever, they may not technically be the owner of the real estate. So be careful, they might have Ryan Investors owns a real estate. I mean, seen a lot with different companies where they have a different, and again, for them, it's tax and liability issues where they have one person entity owns the ground, another one constructs the homes, and you've got to be careful who is signing.
Okay, so that's a good point. I guess I never thought about that. So when we say asset manager, just because they're an asset manager, they may not
That's the
actually
point.
be at Chase Bank and own the property or whatever.
That's-
Okay, so that's interesting.
Yeah, a lot of banks use servicing companies,
Okay, so that would be a good reason why they wouldn't sign such a document because
but they're not the owner.
they're not.
But that just begs the question. You should be saying, get the title holder to sign.
Right. Okay,
Yeah. Yeah,
good points.
yeah.
Mhm.
Okay. What else? I think that's most of what I wanted to cover, unless you have any other questions.
I'm sure we're gonna have hopefully a lot.
Yes.
That's why you're here. So
Okay. I have one.
Yeah.
I've had a couple situations recently where a property was in a trust. Okay, mom and dad are gone, and the attorney tells them to take it out of the trust and put it in each of the kids' names. So there's 6 kids, that means 12 signatures if they're married. Why would they do that? Couldn't you just leave it in the trust
You
and
could,
then settle from there?
you could. But then sometimes in trust, you may have different distributions for cash than the real estate. And if the trust sells the real estate, now the trust has cash, and you have to follow the cash distribution provisions in the trust. In a lot of times, it's all the same, but you're saying, why would someone do that? So that gets it in. Now, the other thing is the stepped up basis. You take that property and you convey it to the kids.
Mhm.
They have now inherited the real estate, they get the stepped up basis in the taxes. So it could be to avoid capital gains.
And they always do it when they're all living in different parts of other states.
Yeah, that's how you track them down.
Yeah,
Oh, and then you get one who has an idiot husband or wife. And it's
Oh.
like, oh, this is fun.
Well, I think that's a good question too, is when you say that, so I've seen it where you have 2 trustees or whatever, the kids, they end up at the house and you have 2 siblings, 3 siblings, and the house ends up in all 3 of their names. And we always tell, the person, well, then you also have to get the spouse's signature if they're married for dower. Is that accurate?
yes,
If it's not in a trust.
if it's not in the trust, once it gets conveyed to the individual.
Because we.
But there could be a significant different tax issue depending on whether it's sold by the trust and cash is distributed, or a percentage in the real estate is transferred and they get the benefit of the stepped up basis.
It's crazy. I mean, I don't know what the benefits, pros and cons are. That's different, but I have seen it. There were 5 or 6 siblings. The house got put in all of their names upon their parents' death, and 4 of them were married. And so they had to get the signatures of each spouse who all lived in different
That
states.
way.
And the
Yep.
purchase agreement had initials everywhere on
Oh,
it.
and I've
Yeah.
seen it too, where then one of the kids has passed away and they had 4 kids.
Oh, geez.
Oh, my gosh.
So in that case, does it automatically go to their children?
The way most family trust situations are, It's called a per piece distribution, which means the share the child would have taken drops to their children.
Wow.
So if there were 4 kids and you would have gotten a fourth, your fourth drops to your 4, so they've all got a 16th.
Good Lord.
Yeah, it can get very messy.
So when you do a trust, is it possible to do a family trust where everything would just stay in it forever? And
Well,
then
you-
it'd be a regular like trustees, and then when they go, then the successor trustees, and then, I mean.
Yeah,
is
but
it- can you-
at some point,
Right,
if you've got kids living in 4 different states, and you got mom and dad's house in Stark County, Ohio,
Right.
and none of the kids live here anymore, why would you want to?
right. But what about if it was just assets?
Well, you
Like if you
you
had
could,
just
but
assets.
again,
Okay,
different families have different needs for financial resources.
all right,
And that's why a lot of times you want to get it distributed that way. Each family has their share and they can deal with it the way they want. Otherwise, you know, you got maybe 2 of the siblings are co-trustees or successor trustees, and they're determining how much money goes to one of the siblings, and it
okay.
gets to be a real mess.
So if you are wanting to protect your personal home, do you recommend us putting it in a trust and assigning trustees or an LLC? What's the best way to protect your personal home as a real estate?
Probably
professional?
6 of one, half dozen of another. They both work.
Okay.
Traditionally, you saw trust. Now you're sometimes seeing the LLCs, but they both work. Is it simpler and cheaper to create a LLC for a single entity? Yeah, sometimes trusts can get complicated and get more expensive to put together. So if it's only to deal with real estate, then maybe the LLC is a more economical answer. But if you got other issues, young parents have issues with children and attaining the age of majority, and when is it good to distribute? I know what I would have done with a lot of money at age 18 or 21. By the time I was 35, it was a lot different. So, I mean, all those kind of things go into planning, and why a lot of times families use trusts. But you can put some of those provisions in the LLC too, so.
It's just with an aging population, we get that question an awful lot, you know, what, to protect your own asset as a seller, if they go into a nursing facility and look back periods and all that fun stuff, what's,
Yeah.
we're not trying to give legal advice, but I know that we always get those questions, you know, what's the benefit of putting my house in a trust or whatever? You know?
And we've had, with, as you say, an aging population where people say, I don't need that trust anymore. And so they've terminated the trust and taken just personal ownership back because they don't want to deal with having to sign as trustee for everything. And, you know, the kids are all grown and got families of their own and all the rest. And mom and dad are probably going to use the money and need it and not have as much to pass on because they're living longer. So, yeah, it's not uncommon for, unless there's a lot of wealth involved, for people to get into their 70s and 80s and terminate their trust.
So is that the difference between a revocable and irrevocable trust?
Yes,
Okay,
an irrevocable trust you cannot revoke
okay, so you put your house in there, that's it forever. So
until
you-
the revocable trust sells it or distributes it according to the trust. But the settler of the trust, the person that set it up, cannot terminate it. And also with a revocable trust, they can't be the trustee.
Say that again.
Wow, okay.
If you set up an irrevocable trust,
Okay, got it,
someone else has to be the
got
trustee.
it, okay. I thought you said it was the other way.
With an irrevocable, yes.
So we do have a question here online. So how many different income sources can be under one LLC? As example, rental property, fracking, royalties, cell tower lease, personal home, how many?
No limit.
There's no limit.
No. It's, the reason you see things split up is generally from a business planning standpoint. How you want to manage that, how you want to shield liabilities, whether you want different potential ownerships and the different types of assets, different management of different types of assets. But, you know, if you want to have 25 different income streams in an LLC, you can.
What else you got, Marcy? Come on. Anybody else?
Yeah, I have a question. So, a father passes away and the son is the power of attorney, the daughter is still entitled to something unless it states something different in their will then?
First of all, powers of attorney are only effective while you're alive. When the person giving the power of attorney passes away, the powers of attorney terminate.
Okay,
You can have a durable power of attorney that stays effective if you become incompetent. But all powers of attorney cease and terminate upon the death of the person giving the power.
so if there was a will or no will, where does the house go then?
Well, if there's a will, then it goes according to the terms of the will.
Okay,
If there's no will, it goes under the Ohio Statute of Descent and Distribution, which basically says close family members, and then keeps looking more and more distant relatives to pass the house on to.
so if that happens, then both kids would have to sign the listing agreement then?
Well, if there's a will, you have to see, is there an executor? Has the executor been appointed by the probate court? If there's no will, or the will had a executor that's deceased, then you have to go into the probate court and have an administrator appointed. And then you have to deal with it through the probate court.
So to
So,
answer your question, no, that you shouldn't be getting a listing agreement signed until you've done what Mike just said, because you have two siblings and your parent, the last parent passed away, whatever that owned it. Nobody has legal capacity to sell that property, which
Right.
means you don't have the legal right to list the property for sale until you've gone through the steps that Mike just described. And we get that question all the time.
and hopefully they use the survivorship deed that takes out of probate, or
So
And
survivorship
then-
would give it to somebody else automatically,
yes.
okay,
Upon death.
upon, right,
The easiest way to say it is that if you have set up something by contract that transfers the property, you know, a transfer on death affidavit or survivorship deed or a survivorship account at the bank, all those things by contract you have set up for it to transfer on your death. That keeps it out of probate. But if you haven't set up any of those vehicles and you own property at the time you pass away, it's gonna go through probate.
Is there, do you have an idea of cost of setting up an LLC? They're all different, so it's a little bit different, but if you had a base,
You know, your ballpark is gonna be about generally $1,100 or $1,200, which includes the $100 filing fee with the state. A lot of times, people, especially in the commercial field, are setting up series LLCs, or a couple of them at the same time to do different things. And of course, when you're doing a couple at the same time, the overall cost is cheaper. If somebody wants to get a lot of sophisticated, different stuff in their operating agreement, it can be more, but that's a pretty good norm.
I hear people talk about due on death deeds. I thought we weren't allowed to do those anymore. Are you allowed to do that?
I'm not sure exactly what they mean by that. There's what we used to call dresser drawer deeds, where mom and dad would fill out deeds and put them in the dresser drawer,
Oh.
never intending them to
Yeah.
get recorded
Yeah. But
unless they
there's
needed
not
to
an
be.
official document that is a due on death deed.
No, but there's a transfer on death affidavit.
Okay,
And that was more flexible than a survivorship deed.
mhm,
Because once you do a survivorship deed, that person transfer on death to whoever, they have a vested legal right in that property.
mhm,
And if you're gonna deal with it, you have to get them to sign off.
mhm.
The transfer on death affidavit says, on my death, transfers to Jane Doe.
Right.
But I can change that at any time. Jane Doe has no vested legal right until I die. So those can be revoked and changed very easily, which is why a lot of people like them better than survivorship deeds. Because,
So that's interesting that you just say that. I mean, I don't know, all of us have been in real estate for a decent amount of time, and I'm sure everybody online
Right.
never heard that before. I mean, the title company doesn't even offer that. It's a general warranty deed, a survivorship deed. They don't ever offer, instead of doing, they don't dive in enough with the consumer to say, is this really your intent? Is this what you want? Or would
well,
you
the transfer
prefer?
on death is an estate planning vehicle,
Okay,
because you're not transferring at that point an interest in real estate. So when you take title to property, you would never use it to take title. So it has to be a deed to you, whether it's a general warranty deed or a survivorship deed. So that's how you get title. Now, once you have title and you're doing estate planning, then it's, all right, should I keep it a survivorship deed? Should I just have a trust? Should I have a transfer on death affidavit? Those are all different considerations that go into estate planning for people.
Another thing we hear a lot is when people, there is a trust, and let's say mom and dad are not doing real well, and then the child will say, oh, I have a POA, I'll sign for them. Well, they can't under the trust, correct?
Well, no, because
Because there's, it's
again, the
not,
trust has a trustee.
great,
It is the trustee that makes, not mom and dad. Now, mom and dad might be the trustees.
Yep.
But when they operate as the trustee, they're operating as a fiduciary of the trust, not in their personal capacity. And that power of attorney is for them to operate in their personal capacity, not as fiduciary for the trust.
so when that does happen though, you can get something from a doctor? And can they do that? Get something from the doctor and then they change who the successor trustee is? or
Well,
not?
that's, there again, if someone is incompetent,
Right,
then they no longer can act as the trustee. So then the successor trustee can step in if they can prove that mom or dad or whoever is incompetent.
Another
I tell
question.
anybody, I can find a lucid moment.
We have another question here. So if the trust has trustees, power of attorney, and executors with backup executors, does that cover all possible potential situations? So again, if you've got trustees, power of attorneys, executors, and backup executors, does that cover all potential situations that you would run into?
Well, but you're mixing and matching. Executors are under a will. And if the property is in a trust, it should never go through probate. So the executors have nothing to do with it. As we just said, the powers of attorney are for the person's personal things. So yeah, if you have a will in a trust, you still have a will because, as time goes on, people might forget to put things in the trust. And to the extent you forgot, or for whatever reason, didn't put any of your assets in the trust, those are going to go through probate. So you still need the will. And that will is what we call a pour over will. It's going to say everything gets poured over into the trust. Unless the person, for some reason, wants some assets handled differently than what's in the trust. And, there's all kinds of reasons people do things. But the executor only handles things under the will through probate. And the trustees handle what's in the trust.
So if there is
So you're hitting the different bases with those things. And yes, if you set up a trust, you still should have a will and an executor. And yes, you should still have powers of attorney to handle your property and your healthcare issues.
hopefully that answered that for you. That's a lot. So if there is a death and you have, and the agent goes out and there is a will and it shows this person as the executor, you could take the listing at that time.
Get the deed and make sure that deed doesn't say it's in the name of somebody as trustee.
Okay.
So if John and Mary Smith bought property and one of them passes away and it's in their names personally, yeah, you need to see the will. And has a probate estate been opened? Or was there a survivorship deed? And if so, has someone prepared what we call an affidavit of death that you file in the recorder's office with the death certificate attached to show now the survivor and the survivorship trustee? or survivorship deed, or the person taking on a transfer on death affidavit, it's now their property. And you do that with that affidavit of death that has the death certificate attached to it.
It might just be easier if you just come with us on the listing of.
Oh.
So many different situations, right? Yeah. You're gonna start a new kind of practice, Mike.
So what if you have a buyer who does not have a trust, but they want to, whatever house they're buying, they want to put it into a trust? What point do they set the trust up? Like at what point do they? do all
The
this?
biggest consideration there is their lender.
Okay.
Because if they're borrowing money to buy that house, the lender may insist that they do it personally, then put it into the trust.
Okay.
If there's no lender involved, then they could take title right in the trust if it's already set up. But typically, lenders are going to require it to be taken in the personal names and then put in the trust.
Okay.
Mike, we have one more online here. So how would an executor sign listing paperwork or purchase agreements? If you know they are the executor of the estate and they have power to do that, how would they sign this?
They would sign it, John Doe, executor of the estate of Bill Smith. And Bill Smith would be entitled. So that's why you tie it together with saying that they are the executor. And that should mean that you know there's a probate estate you're going to be dealing with. And then of the estate of, so you can tie in the record title of who is entitled.
So with our wonderful technology today, like .loop and online signing tools, when you go to initial, that obviously cannot all fit. Every single one of those are not going to fit in that initial box. So
There's some long initials.
there's some long
There's some
initials.
long ones.
Yeah.
What do
If
you
I
recommend
was
for
a
this?
reviewing attorney for, say, a buyer, the other side, or working with the title company, and I saw John Smith, executor of the estate of whoever, and then just John Smith's initials, I don't think I'd object to that. Now, some people might, but I think as long as in the signature block, it's very clear who John Smith is.
Yeah, but in .loop, you have to use the same. You
It
can't have two
automatically
different-
matches.
It automatically
Yeah.
matches the signature, which just have a million letters.
Yeah, you said.
Yeah.
Okay. And I'm sorry, one more. Okay, so with a transfer on death, does the loan on the property transfer too?
No. No.
But
And
they can
it's the
still
same with
foreclose.
divorce. We get that in divorce situations all the time. Just because people are divorced does not mean they've been released the liability on the note and the mortgage. So that's where it's a much bigger issue.
So basically, if your parents pass away and they still have a loan against the house, you better be making the house payment in a timely fashion because they still can foreclose. on
Absolutely.
that.
Absolutely.
Anybody else? I know we've asked a million, but this is good information.
Just you had said something about, with the LLC paying yourself a salary.
Well, I'm just saying that with an LLC, forget it, the context that came up, but a lot of times with LLCs, people do pay themselves. Sometimes they just take distributions out. It just depends on the type of the company and the income. And a lot of times you have to work with an accountant on that because your tax liability and different taxes that come into play with whether you take a salary or whether you just take distributions. Since you're not, it's sort of like the problem with the real estate industry between being an employee or an independent contractor. There are different taxes that get paid on wages. And generally with small businesses, the IRS is going to expect that you took at least a reasonable salary out of the business for whatever reasonable salaries on that industry are. And the balance you can take as distributions. But those are generally IRS questions, depending on the industry and whatever. But legally with an LLC, you can pay yourself a wage and you can take distributions.
Okay.
All right, guys. Well, thank you so much. If you guys do have further questions, Mike is available. He's got cards up here on this document. You've got his email and phone number. So if you're looking to set up an LLC, you can get a hold of him or any other questions your clients might have.
Yeah, and Jamie Heron was gonna be here and work with me on some of this today. I don't know if you all know Jamie, but she had serious babysitter issues this morning.
Uh-oh.
And so I solved it by saying, I'll just do it
Oh.
myself, so.
Well, thanks very much.
But that's why you'll see Jamie's name on here, and if I'm ever not available, feel free to call and talk to Jamie.
Oh, that's sweet.